Thanks for joining us today. I'm Kevin McNamara, and I'm joined by a special guest. I have Michael Working here from the Working Law Group. Michael, thank you for being here. We appreciate it.
Well, thanks for having me.
Yeah, so we're here to talk about the Hernandez Govan case right now. He's accused, the alleged mastermind in Young Dolph's murder. I guess from your perspective, just give us kind of a general outline of what the state is looking for here.
Well, the state is always looking to remove doubt from the jury's mind. They want the jury to be morally certain that they've got the right person. In this case, this is a conspiracy case. Mr. Govan is not alleged to be the trigger man, and so they have to connect the dots of all the pieces in the conspiracy and then show Mr. Govan was a part of that conspiracy. If you participate in a conspiracy, you are liable, you're guilty for all of the acts of the conspiracy. So you don't necessarily have to be the gunman in Tennessee to be guilty of murder, but you do have to be in the conspiracy. The term we use in Tennessee is called criminally responsible for the actions of another. And that's ultimately the state's goal here, is to prove that Mr. Govan participated enough to be criminally responsible for the shooting in this case.
So do you think that makes it easier or harder to get a conviction then? Because if you're not talking about physical evidence necessarily.
Well, I think it depends on who you're talking to. Prosecutors will say it makes it harder because we have to prove the person who is not the gunman is guilty of murder, even though they didn't physically commit the murder. Defense attorneys will say, this makes it way easier because it's just this whole big, world. Anybody who's connected at all to the gunman can be found guilty. So, kind of just is your perspective. I do think that it's hard for the state in this case in a few ways. Number one, there's like several steps in the chain, and people above, as alleged, people above Mr. Govan in this chain are dead and will not be testifying. So the defense in this case has the ability to argue that the actual gunmen were not, in fact, in a conspiracy, and there's no way to connect this whole big conspiracy that they say exists because nothing, goes on the other side of Mr. Govan, above him, I guess, in the chain of command, so to speak.
Yeah, is that unusual, or is that something that's more common in cases like this?
Well, it's not necessarily required for the state to prove anybody is beyond Mr. Govan. They just have to connect Mr. Govan to the gunman, right? But as is alleged, there's this whole bigger conspiracy with Mr. Govan being a middleman. It gives the defense an opening to argue he's not in the middle. There's nobody on one side of him. And the murderers who are just trying to save themselves are on the other side, right? The gunmen, the triggermen, who have plenty of problems. One of their girlfriends was testifying this morning about he had a bad pill problem and, he was in addiction and that kind of stuff. And then the other guy's been convicted of being the gunman. So the defense certainly has some room to argue they're trying to save themselves and get a more lenient sentence. Right.
In a sense, there's kind of raises the question of, if we've got two people in jail for this already, we know pulled the trigger, what is even the need to have Mr. Govan behind bars?
Well, I think that's something that the defense will certainly argue.
Yeah.
The state will argue we're going to try to hold everybody responsible that we can. So, and that's our job, that's what justice demands, is that everyone responsible will be held accountable. And I think the defense is going to turn around and go, well, the people who are responsible have been held accountable. One of them was convicted and the other one is in jail and about to be.
Right. And the defense doesn't need to come up with any kind of alternative narrative necessarily, just the one that the state is proposing not being inaccurate.
Legally, the defense doesn't have to do anything but cast doubt about the prosecution's case. In practice, if you're someone who tries cases, yes, in my opinion, the jury does have to hear a story that's believable for the defense, if people are going to listen to you, you have to have a story and you have to be a good storyteller. I mean, when I came in today here in the lobby, there was a big sign: "We are storytellers." You know, we are truth tellers. We are fact finders.
That's right. Very perceptive.
These are all the things that a defense attorney has to do. If you really want anyone to listen to you, just like the audience, just the jury is the audience, and they vote at the end, and they need to buy into your story. So the jury, you know, they'll say, "Yeah, you don't have to prove anything. The state has to prove everything." Well, that's true, but to be effective, you have to have a good story that they'll believe. And I think that the story for the defense is obviously going to be that this fellow, Mr. Cornelius Smith, is desperate to try to save himself and his future, and that, you know, he's trying to say anything. This fantastical story about a big conspiracy that reaches to the highest heights of the world of hip hop. You know, can't believe that guy. He's just a junkie. So that's what the defense is going to be, probably some version of that is what they're going to be pitching to the jury.
Right, and I think the story is especially important in this case because we don't have there's not a ton of physical evidence that's going to be connecting Mr. Govan to the crime.
Right, Mr. Govan is not going to be the person on video outside of Makita's Butter Cookies shooting into the store. He's not going to be the person putting not just Young Dolph's life in jeopardy, but the employees of the cookie store. So, you know, the defense is going to have things to argue and work with and be credible, but the jury is also going to hear from the state that, you know, this was a huge case they investigated. Here's all these reasons we think Mr. Govan's connected.
Yeah. Now, of course, something I'm curious about is, as we're talking about, there's different monetary amounts that are proposed to have been offered to Cornelius Smith as well as others on what the payment was going to be, allegedly, for Dolph's murder. No money was ever exchanged, however. There was no...
Right. So, you know, again, that goes to the credibility of the state's witnesses, right? In the courtroom, outside the courtroom in politics, the word impeachment usually means someone is unfit and being removed from office. Inside the courtroom, impeachment means that a jury, a witness can't be believable. A jury can't really believe the witness. They've been impeached with their bad credibility. So the fact that there's been these fantastical amounts, $1.5 million, $1 million, 100,000, maybe people got nothing. The jury will have to determine what the truth is. That's actually what the word jury comes from, the Latin juris for the truth. And they'll have to determine, was there money exchanged or not? And, you know, the defense will argue these are the actions, these are the fantastical claims of, you know, a person in the grips of addiction who's delusional about how important they are, delusional about how much money is involved, delusional about what record executives at the highest level were involved. This guy has all the makings of a crazed lone gunman trying to make a name for himself by killing someone famous, you know, just like John Wilkes Booth or any other assassin. Right.
So I guess in this case, then, it is going to be about, is that story credible? Because there's not, it's just text messages that they're going off of then? Is that the evidence that's going to be considered? Is connecting Govan to them?
Well, text messages have become perhaps one of the most important, most consistent, most common, and most credible forms of evidence. We all go everywhere with our phones. And if you're talking on the phone, it will say that there's been a call between two people, but it doesn't show the contents of that call. But the text messages really get into the contents of what people are talking about. And so, you know, it gets harder and harder to explain things that look incriminating in a text message. And so text messages, not just in this case, but almost all cases, are some of the best evidence that's ever offered to a jury.
Right, and that's presumably what they're going to have connecting Govan to saying that he's making these, he's the one in charge of this operation. Because there's no, again, he's not the one pulling the trigger.
Well, I mean, they'll also have testimony, as they did, I think, yesterday from Mr. Smith, who was believed to be connected to Mr. Govan.
Right. But as you were saying, it's can you trust these people then? If
Right.
that's the defense is going to be make that
So
argument.
just like inconsistent statements about the amount of money impeach a witness and cause them to look less credible because the statements are inconsistent, text messages could be used to bolster credibility if they're consistent with the testimony. And of course, if they're not consistent with the testimony, it makes the guy really look not believable.
Yeah. So it seems like there's a lot of hearsay, as we were talking about, right? It's a lot of this person is saying that Mr. Govan did it. Other people are saying, or Mr. Govan's going to say, I didn't do that. And who does the jury believe in the end?
Right. So hearsay gives lawyers fits. It gives law students fits. It gives judges fits. Hearsay is probably one of the most complicated legal doctrines there are. And what I think in Tennessee at the moment we have about 30 times where there's something that's an exception to hearsay, and then 6 or 7 more times where the rules say, well, that's not actually hearsay. And so when you get to up in the neighborhood of 40 different times the statement,
Right.
there's a rule about whether or not that's really hearsay or not. It's one of the things that is argued the most in courtrooms. And yes, that is the problem in a conspiracy, that you have all of these statements that people have made out of court, which is what technically qualifies as hearsay, and whether they can be used in court. All these things people said out of a courtroom when they weren't under oath, when they weren't being serious, when it wasn't the solemn occasion of coming in front of everyone and said, I promise to tell the truth.
Right.
You're just talking. And so should that be used in the courtroom? And then we have the other question, as defense attorneys, you have the right to cross-examine and confront your witnesses. That's a constitutional right, the confrontation clause. There's people alleged in the conspiracy who won't ever come into the courtroom, who are deceased.
Yeah.
And they're never going to be able to be cross-examined or questioned about their statements made in text messages. And so likely a lot of the text messages won't come into the courtroom. So very technical stuff. And, you know, I don't want to get in the weeds and bore you with
I'm
real
not bored at all.
textbook lawyer stuff, but, you know, hearsay is some of the juiciest and wildest stuff that can make any trial go one way or the other on the seesaw of justice, but certainly in a conspiracy trial.
Right. So I guess, you know, what's separating this trial from maybe some of these other high-profile cases that we've seen here in the Mid-South over the past few years is there isn't that smoking gun, as it were, that physical evidence that's going to put Govan anywhere near these crimes that were committed. It's all kind of secondary.
That's what the defense will certainly say. The defense will say there is a smoking gun. It's on video. It's right there in front of Makita's butter cookies, and you're going to see that Mr. Govan is not holding that smoking gun.
Right.
So it becomes a question of, can they connect him to the smoking gun? And probably text messages are the strongest way to do that.
Right. But, you know, a text message from him saying, I didn't do this, that's not going to help his case too much, right?
Well, there's rules about that.
Right.
There's rules about what's called self-serving hearsay.
Right.
Statements that Mr. Govan makes that help himself aren't necessarily allowed in. Statements that Mr. Govan makes that are real bad for him are allowed in.
Right. Anything you say can and will be used against you, never for
right.
you.
Never for you. Never for you. And, you know, Mr. Govan didn't write any of the rules of evidence, but the state of Tennessee wrote them all. So, you know, big advantage for the state of Tennessee usually in that regard. But generally speaking, text messages are highly persuasive to juries because they're seeing what was happening in real time. They're time-stamped, they're dated. And so they're saying, oh, this is like, you know, 2 days before the shooting. This is 6 hours after the shooting. And they really know what's happening in real time from that data.
Yeah. Is it on the state to also make the case of why Govan had this amount of money that he was able to offer, or what means or motive that he had to, you know, kill Young Dolph or have Young Dolph
motive
killed?
is not required to be proved in Tennessee, but it's certainly very strong circumstantial and persuasive evidence of why someone would commit a murder for money, right?
Right. Why those?
For a record contract, for notoriety in the hip hop world.
Right.
It's not required to prove motive in Tennessee. You have to prove that someone acted intentionally with premeditation to take another person's life, to kill another person. But you don't have to prove why they did it. But obviously, the facts of this case, there's a rap beef between record labels. There's young people who are trying to become more well-known as rappers, and there is a certain subculture of rap where, it can be a violent genre. So all of these things are motive. None of them are required, but they help sell that story to the jury, make it more sense so that the jury can believe something that's frankly believable.
Right. So does the state need to connect Govan into that rap beef then and say that this is...
They need to connect Govan to the shooters.
Yeah.
That's what they need to do. Now,
Right.
if their story and the motive is the shooting happened because of a rap beef, sure.
they don't need text messages to prove that necessarily, or do they? Or they don't need to prove that, I guess you're saying, yeah.
Anything that's going to connect him to the shooters
Right, to the
before or
shooters,
in the
yeah.
hours right after the shooting is going to be highly persuasive evidence to the jury.
Right. But what's connecting Govan to the rap labels necessarily doesn't, even if it's not to the shooters per se, that doesn't...
Well, I think that's the big X factor in the trial. The big X factor in the trial is this is a rap beef, and we're not going to hear from Big Juke. We're not going
Right.
to hear from anybody above Mr. Govan in this chain of an alleged rap beef.
Yeah.
Right? So that's the X factor. Would the jury discount the whole thing because other people in the rap world have also been gunned down? I mean, probably not. It's probably pretty believable that people in the rap world have been gunned down, or that there's been
Right.
reciprocal beef and reciprocal violence. But it's an X factor because a lot of that evidence won't come in because Big Juke's not going to testify. And it's not necessarily required to go up the chain. You got to connect him to the shooters.
Right. So is the state is saying that he is a middleman then?
I believe that's the state's theory.
Right.
From comments I've seen, and I haven't watched the whole trial, but I've been in and out of the courtroom a few times, and from what I've read about trial or seen reported in the media, but it's my understanding that he's the middleman. And it's certainly an X factor that there's not really a way to prove a lot of what's above Mr. Govan in this chain.
And they
of
don't need
command.
to. They can say,
That's right.
hey, he's the middleman, but we're stopping this at the middle,
That's right.
It's kind of an interesting thing,
That's why it's an interesting trial, certainly.
Like if you're going to say that we don't think he's the source of the beef per se or the money, but he is the middleman, and we're going to say justice is served if we're putting this man behind bars.
Right, that's the state's theory.
That is the state's theory. Well, that's kind of all my questions. Is there anything else that you'd want people to know?
No, I would just say, a lot of times when everyone is paying attention to a trial, they may not like the result, they may not agree with the result, but juries get it pretty right about what happens in the courtroom. I mean, when you take about 15 people and you take them away from their families, you take them away from their home, they're sequestered, they watch the whole thing. They're really invested in getting it right. And then they pick 12 of those folks and go off into the room, and they all have to agree.
True.
That's what a unanimous verdict is. When do people in this town all unanimously agree, right?
On anything.
You don't agree on the presidential election. We don't agree on the mayoral election. We don't agree on whether XAI is good for the city or bad for the city. The people argue about everything, but a jury in a criminal case has to be absolutely unanimous. All 12 people, based on what they saw, dedicating their life to 8-10 days in a trial. So I would just say the juries generally get it right based on what they see.
Well, you certainly would hope so. We hope justice is served one way or the other. Michael Working, appreciate you being here. Thank you. That's all we have for you this time on ABC 24. Take care.